Dear students, so welcome back to property law, and that would be HOE 6011. And well, we are looking at different aspects of property law right now. So we finished mortgage last time, yeah, and then looked at different types of issues that can arise with mortgages. So that was in the previous video lecture, and now I'll continue on and talk about lease, yeah. So basically, remember it's sales, mortgage, lease, exchange. These are the main, and then there's of course gift and other stuff as well. So now when we look at a lease, well, yeah, we'll be looking at different issues that can arise, again, from a legal viewpoint, the different aspects that can be seen in this case. Now, remember, when you have a lease, it can be a bit confusing because it's also quite similar to a license, but that's not entirely true because there are some very important differences. And well, I'll try to talk a bit about some of these issues. Also remember, homework 3 is up. Yeah, so um, about 2.5 weeks more to go. Then soon I'll put up homework 4. Yeah, that should be about wills, and then there is homework 5 also. Yeah. So well, we'll be talking about a few things in the meantime, and the exam dates are up as well. So where are we? We're looking at lease, and now when you look or consider the issue of a lease, it could be very deceptive or very tempting to consider something that you or most of you are familiar with, which would be a license. Now, the principal issues are quite distinct, but there are some similarities. But let's just keep it simple. All right. So basically, you are, let's say, from outside Tallinn or outside Estonia, and now you have come to Estonia, to Tallinn, to study in Taltech, and so you would like to now stay in a place. Of course, it could be in a hostel or it could be a rented apartment. So well, most often what you would go through would be a license, and it just gives you a bare permission to stay in a certain place. You have no rights whatsoever. And then, of course, well, of course, you have some rights of privacy and things like that. But generally, it's a very simple sort of arrangement. And the landlord, landlady can come to check you out or the flat out often, and it's usually for a year, and you pay up some money, and then of course you have some arrangements regarding do's and don'ts, and what are your rights and responsibilities. Basically, you are responsible for paying the rent and making sure that the cops don't turn up every second day. And of course, what are your rights? Well, simple rights. You have a right to enjoy your stay, and not to be disturbed, and that's it. Simple stuff. So a license basically is a very bare permission. There's no transfer of interest or anything. There is no inheritable right, nothing of that sort. All right, you have really no rights. If you make any improvements, if you do anything to the flat, no, you're not even supposed to do anything of that sort. Okay, basically, the flat is just some place you're supposed to, just eat and sleep over there. That's it. So that's very different from, of course, a lease, which is a much more robust situation. It's more well defined under the law. It's more long term. It's more properly, taken into account as far as legal issues arise. And so we'll be looking at a lease. So it's not exactly a license. Let's say a license is a baby of a lease. All right, it's a really insignificant thing. It has some similarities, but not really. So what is a lease? Basically, it is a contractual agreement, yeah, and by which one party conveys an estate and property to another for a limited period, subject to various conditions, in exchange for something of value, but still retains ownership. So basically, it's a transfer of a right, transfer of an interest in a specific immovable property, and of course, for consideration. And consideration would be the price that is paid. Now, in this sort of a relationship. There is a lessor, the one who owns the property and gives it out on lease. Then there is a lessee, the transferee, the one who takes the lease. Then, of course, you have this premium, the rent, and whatever is payable. And so there are these different legal definitions that go with this entire phenomena of a lease. It's the same like with mortgage. You have a mortgagor, mortgagee. With a sale, you have a seller, a purchaser. So these are definitions that you have to take into account. And then there could be some simple issues that arise. What are the rights of a lessor? Maybe you could have a lease for 10 years. Maybe you could have a lease for much more period of time. Sometimes you have lease of 99 years, especially in a lot of these countries which are influenced by the UK. You have these ridiculous 99-year lease or things like that. Now you would say a 99-year lease is as good as a sale, but of course all time frames and periods do come to an end eventually. So what may seem like a very long period of time, 99 years, can end quite fast. And so where would such a situation arise? Basically, maybe let's say you are in the restaurant business. Yeah, not a very good business at this point of time, but yeah, you could be. Or you're in the hotel business or something, and so there's a very nice property, and you take it on a long-term lease. And so then you run the property and whatever, and the owner, of course, is happily getting a share of some profits or whatever as rent payments and things like that. So again, with a restaurant, you would make a lot of investments and do the decor and the kitchen and where the customers will sit and eat, and maybe you have a band and all those sort of things. So you have to make a lot of structural alterations. Now, when you talk about a lease, you should also remember that in many legal systems, a lease could also be inheritable. So let's say I take a lease for 99 years. Now, I'm 45, 46, so of course, I'm not going to be like 143 years old. So you have a situation where you have a long-term lease. There's a transfer of interest, and what happens if the lessee dies? Then can his or her family inherit the lease? Then again, you have to remember that there are a lot of statutory protections that are also afforded, which is why this sort of an arrangement can cause legal issues. And so you can see why licenses are more preferable, because a license is a bare, simple permission to do something. The licensor can just come and slap you, and out you go. Of course, under certain restrictions, and there would be issues that can arise even in a license. But let's not talk about licenses so much. We are more into leases, and so you have different types of issues that can arise. Sometimes a rent to own lease. So I've given you some examples over there. It's also, for example, in Estonia, it's very popular. It's leasing for a car. So you could also lease that. But we're not talking about these things over here. It's immovable property. So but there are some aspects of lease which can also apply to movables. So, what are the rights and liabilities of a lessor and lessee? Again, a very relevant topical question from a legal viewpoint. And if you notice, very often what is the right of a lessor becomes the liability of a lessee, and vice versa. So that's one good way of remembering this for the exam. Of course, it's an open book exam, so you don't really have to care much now. If it was a closed book exam, then maybe it would have been more relevant for you to know that if a lessor has a right to receive money, then a lessee has an obligation to pay the money, things like that. So, rights and liabilities of the lessor. The lessor is bound to disclose to the lessee any material defect in the property which the lessee could not find out, even despite exercising ordinary care. And this can be quite relevant. For example, let's say um, I'm going to lease out a premises to you, and you are the lessee, and you want to set up a restaurant, and you do your background search and everything, and everything looks fine. But then it turns out that I cannot actually have commercial um, you know um, interaction in my premises, and it's some new rule which you are not aware of. So of course, these are some of the material defects that can arise. It could also be a structural defect. It could be a defect in the property. It could be a giant mushroom growing somewhere. Maybe some poisonous snakes around, things like that. So of course, all of these play a role. So the lessor is supposed to disclose whatever is of relevance, which basically means should disclose everything. Then the lessor is bound on the lessee's request to put the lessee in possession of the property. Yeah, so that's after the agreement has been signed. Yeah, and um, as long as the lessee is paying the rent and performing all the contractual obligations, then the lessor should allow the lessee to enjoy the lease without any interruption or any possible interruption or any issues that could be of a problem of sorts. So, what are the rights and liabilities of the lessee? Well, yeah, simple things. Of course, if there is a fire or some unnatural event which makes the lease property permanently unfit for the purposes for which it was let, then the lease at the option of the lessee can be voided. Yeah. So again, very relevant, because if you have something for 99 years or 10 years, these issues can arise. Now, sometimes it could also be that there's a lessor, and as a lessee, you have informed the lessor that there is a leak in the roof, and the lessor is not taking any action. So in that case, as a lessee, you can repair the roof and then tell the lessor that I'm going to deduct this money from your monthly rental payments. So again, you can do such things. And of course, well, the problem that comes up over here, as you can imagine, is maybe it's a simple roof leak, just one small part, and you could get it fixed for 500 euros, but you change the entire roof and that costs like 20,000 euros. Then of course, that's how problems can arise, where a lessor and a lessee are on two sides. So this issue should be taken into account, and you have to be careful about this. Now again, we're talking as lawyers in this class, so there are a lot of these aspects that can arise. I'm just giving you examples of the worst case scenarios very often that can come up. And then of course, yeah, well, so yeah, if the lessee has attached certain properties to the immovable property, then when their lease is terminated, then of course he can remove whatever these permanent attachments were. Then there's also the issue of if the lessee is aware of something which the lessor is not aware of, then the lessee should inform the lessor, and this could often be related with issues. Maybe there is some hidden treasure or something. So this was also discussed in sales, but there are some examples of this, quite strange ones, and they have to do with Banksy. This artist who draws graffiti on the walls, and some of them are quite popular, and apparently they sell for quite a high price. And I think even in the news forum, I've put up some information about this Banksy mural removed, and so you can see those sort of things. And well, some of this is very relevant because of the examples I've given here. There's a Banksy mural art dispute in the Moodle course. So it's a news item again, something that will make sense. Right now we're just having a bare reading of various issues, but when I give you the examples, hopefully they will make a lot more sense. All right. So then again, what are the other issues? Yeah, the lessee is bound to pay rent on time and keep the property in good condition. And of course, if there is any issue, then sort it out. Also, allow inspection by the lessor or her agents or whoever. So very simple things. A lot of parallels with what you see when you license a flat out. But although, as I said, remember, lease and license are two different legal animals. Okay, they're not the same. So one's a tiger and the other is a fox. All right, so they're not the same, but they have some similarities. And then, of course, if there is any defect, how do you give notice about it? Is it in writing or whatever? So that would be drawn up in the lease agreement. Now, if there is any encroachment, then again, let's say it's a piece of land and 5 hectares, and now somebody else is sitting on this property, then in that case, the lessee should inform the lessor immediately that, there's somebody here causing problems. There's also the issue of how to use the property, and well, as a person of ordinary prudence would use, which would mean, for example, it's cold, you want to set up a fire, you do that in a fireplace, not in the middle of the room. Same goes with appliances, or you don't damage the walls, or you don't do something crazy that would cause issues. So again, well, a lot of these things are quite simplistic. Yeah. So that's here as well. Then of course, you cannot erect any permanent structures without the lessor's consent. And on determination of the lease, the lessee is bound to put the lessor into possession of the property, as it was when you first took the lease. So it's quite similar, for example, with a license agreement. Yeah, you have a flat, you stay in it for a year, and the termination of the license arises, yeah, or occurs. So it's a flat for 12 months. 12 months get over middle of March or middle of April. And now in that case, before leaving, you get the house or the flat properly cleaned by a professional cleaner, things like that. Yeah, so it's quite similar with what you would see in a lease. So, where are the problem areas that come over here? For example, we spoke about when you take a lease, as a lessee, you have to make sure that the property is given back to the lessor in the same condition, more or less. There will be some natural wear or tear, of course. Nothing gets younger, everything gets older in life. So as the years progress, so here's an example of this. Somebody took a house on lease, yeah, and so this was in the UK, and it's a nice house, white wall and stuff, and outside walls. And then it turned out one day he woke up and there was graffiti on the wall. So the lessee is like, what the hell, outside wall facing the road, and there's some graffiti on it. And well, normally if there's graffiti, what do you do as a lessee? You would whitewash it or cover it up, or paint it or whatever. But in this situation, it was realized that this is a graffiti drawn by the famous graffiti artist Banksy. So now you have a issue here. I am the lessee, you are the lessor, you gave the house to me on lease, I'm living in the house, it's got a nice exterior, and now this very famous graffiti artist has drawn a graffiti, painting, art, whatever, on the wall. So what the lessee did was, well, he realized that this painting art could be worth thousands or even much, much more money. So he hired a professional company that removes the plaster from the wall without damaging the bricks. Yeah, yes, it's very expensive. It's not straightforward, of course. So there was this entire operation done, and that part of the wall, the outside plaster was removed. Maybe some of the bricks got damaged, and then the lessee got in some builders who repaired the bricks and replastered the wall and painted the wall. And now the lessee wanted to sell this art at an auction, and of course, it's worth a lot of money. Now these sort of things cannot be done secretly, right? So obviously the news came out, and the lessor, the original owner of the house, said, what the hell, what are you doing? This Banksy art belongs to me because it was on my house. And the lessor said, well, no, legally, as a lessee, my thing to do is that I have to, give you back the house in the same condition that I got it in. So when I got the house, it didn't have this mural art on it, and I'm giving it back to you, the house, just the way it was. So whatever this graffiti was, I took it out. I can do whatever I want to do with it. So you can see how these sort of issues arise. A lot of these are problems that can come up when you have these sort of lease arrangements and things. So, well, if something is worth €500,000 or pounds, then of course everybody gets very creative ideas. Then rights of a lessor's transferee. Well, what we are looking at over here is when, let's say, I have leased out a house to you for 5 years, and now I sell the house to somebody else. So what are your rights as a lessee, and what are my rights as the new owner of the house? So all of these are covered over here. Now just keep in mind, because in some countries you have statutory tenants and statutory tenancy rights, and these go hand in hand with the lease. And then you can have a serious problem, because if this person is a tenant, then there are a lot of restrictions. I believe these also exist in many countries, in Finland and Sweden, for example. Rent control plays a role, and you cannot just rent out the premises. And these come under the Rent Act or the Tenancy Act. And so again, there are a lot of these gray zone areas where, is it a lease, or is it a tenancy, and is it a license? So you have a lot of these questions that come up, which basically mean that you would now have to know the property law, you would have to know the rent law, you would have to know, the contractual obligations law, where licenses are generally referred to. So again, a lot of overlap happens in many situations. But as a lawyer, then you have to sort of figure out what is what. Another issue that can be is, you draft a legal agreement and you say, I have a house, I'm giving it to you, and you say everything except the word lease in it, or the word license in it. And now when this matter goes to court because of a dispute, the question is, well, he has an agreement which says, I allow you to stay in this house, and I give it to you on rent, and the rent amount is so much, and this will be the period of the rent, and so at the end of it you have to leave. But now it's very unclear whether this is a lease, or this is a license, or what is it. So maybe such an agreement was drafted, by people who didn't realize what they were doing, or people who knew exactly what they are doing. And so when this sort of a situation goes to court, then the court will have to sort of analyze the document and what is written on it, and then try to sort of deduce whether it is a lease or a license. So again, a lot of issues that can come up in these sort of situations. So, well, a characteristic aspect of a lease is that it is not a permanent transfer. It's a temporary transfer. And so you would have determination, which is when does it end. That could be either by the time. So, it says specifically that this contract was drawn up on the 5th of March 2020. And this contract comes to an end on a particular date. So that could be a situation. Or sometimes you have this weird clause which says that, well, when the agreement is coming to an end, then as a lessee you have to say, or the lessor has to say that, yes, I want to end it. If you don't, then it is presumed to continue. And again, you can have consequences for this, because then you have to pay rent. The license, the lease agreement is ongoing, it's continuing, it has not determined. So, well, there are these contractual issues that one has to be careful about. It could also be that the lease may end or be determined on the happening of a certain event, and this could be a conditional lease. Now, this takes us to that awful chapter on transfer of property, where we had conditional, contingent, and all of these issues. So these can also be a big part. Now, why would this be relevant? Let's say you represent a client and your client owns a shop in a shopping mall, all right, in Stockman or in Viru Keskus or whatever. And it's a shop, and so your client sells stuff, maybe as a restaurant business or something. And now there is this pandemic, it's the second year, and of course, it doesn't make sense to have a lease for 5 years when, out of those 5 years, 2 years have already gone and there's no business happening. So, could you then say that because of the coronavirus, I want to terminate the lease? Now, this again brings up very interesting issues because usually in the past, you would say that, God made events or acts of God or acts of nature, vis major, whatever. If that happens, then the lease would get terminated. The same goes with, for example, business premises. How many companies actually own the premises where their offices are? Why should they do that? They can get it on rent. So these are long-term rental lease arrangements. And now, well, because of the lockdown, you can't go to work. Employees are working from home. Offices are shut, and so can you wriggle out of such a lease agreement? And you can say that, well, the pandemic is an act of God. Well, you see, so these are issues. A lot of these came up big time last year, and because of the circumstances, you can understand how this can be quite problematic. Of course, not and there were not many agreements in the before 2020 which would have a clause which states about pandemics or epidemics or coronavirus. But now, if you were as a lawyer to draft an agreement for a lease, maybe you would specifically put in a clause stating that in case of a coronavirus pandemic or a shutdown by the government, then the lease would be determined. If the shutdown is for more than 2 months or 4 months or 6 months, then again you see very interesting aspects which people never really thought about. But with the coronavirus pandemic, all of these sort of come up, and a lot of attention is now paid to them. And this is all especially significant because in many countries, you read in the newspapers how the business districts are emptying out. Even in Estonia, in Tallinn, from what I understand, a lot of the commercial premises are quite empty. Yeah, so that's a huge issue because a lot of companies and uh, uh, businesses are now operating from remote locations, from home, and things like that. So they have a very small number of people who actually come to office. So again, very interesting issues that can be seen in this regard. Then, where it states that if the event happens, then the lease will be determined or terminated. In that case, then there's also surrender. You just go up and say, well, by mutual agreement, I don't want to be in the lease arrangement anymore. I want to give up the lease. There could be a forfeiture, there could be a specific express condition, and now the lessee has broken that condition, in which case the lease would be forfeited. It could be because of insolvency, it could be because of yeah, some fraud issue or whatever. And lastly, of course, there's a notice period. You give the notice, and the notice says by mutual consent, or if either party gives a 1 month notice, then they can walk out of the lease. So again, legal aspects over here. And then, of course, if you accept a new lease, as I mentioned, so let's say the lease ends on 7th of April 2021, and on the 6th you send a letter to the landlord saying that you want to not give up. Then in that case it continues. But on the other hand, you want to give up, then of course you have to give specific notice in this regard. So again, very simplistic. I try to talk a bit about different aspects over here, but as you can see, the major takeaway from this particular video lecture is that terminations or determinations or these sort of clauses are very relevant nowadays, and play a big role in understanding how lease arrangements are, because you can't just simply walk out of a contractual agreement or arrangement, especially in the form of a lease. So just as the lessor has rights, the lessee also has rights. So we continue on, and next would be exchange. Exchanges are somehow, let's say, in a context. Well, in the historical sense, this would be the ancient barter system, and this was quite straightforward, right? I mean, there was no money as such at that time, so you have 100 apples, I have 25 mangoes, and then you're like, what the hell is a mango? So you do an exchange, and you sort of presume that 100 apples is equal to 25 mangoes, so the ratio or whatever is. Now, exchange, of course, is also, for example, with money, which would mean I have 100 pounds and I want to exchange them for euros. So again, you see what you're doing here is you are doing a currency swap. You are exchanging 100 pounds for I don't know, 90 euros or whatever the price is. So again, what the definition would imply is when two persons mutually transfer the ownership of one thing for the ownership of another, neither thing or both things being money only, the transaction is called an exchange. And of course, this could also be a situation where, let's say, I read about this. This was quite interesting in a strange way. So there was this Finnish family, and they owned a manor house in Estonia. Quite a well located manor house somewhere in the middle of Estonia, an ancient, 400-year-old house. Some Baltic German landlord had owned it at one point of time. So anyway, so this Finnish family had a manor house, and they probably thought that it's good fun. You're living in Finland, you're working in Helsinki, and then you can come sometimes on the weekends to Estonia, stay in the manor house. Yeah, feels very posh. And when you're going back, then you can also take 100 bottles of beer with you. Yeah, so win-win situation in the good old days. And after a point of time, they began to feel it's a bit stupid having a manor house, the country house, the charm goes away. And then there was an Estonian couple who had a very nice house, quite modern and well maintained in Nomme. And Nomme is, next to Taltic actually, but it's a suburb of Tallinn. And somehow the Estonian couple and the Finnish family met, and the Finns were like, "Oh, we want to get out of this stupid manor house. Just don't think it's worth it. Doesn't suit our style anymore." And on the other hand, the Estonians were like, "Wow, I mean, you have such a big house in the countryside. That's what we would like to have." And so they had an exchange agreement, arrangement of sorts. So the Finnish family got the modern house in Nomme, yeah, in Tallinn, and the Estonian family in exchange got the old country house, manor house in the middle of Estonia. So again, you see, this is an exchange. Sometimes, of course, it could also be, it's like you have a flat in Helsinki, it's worth a lot of money, and then somebody has maybe 3 flats in Latvia, Lithuania, and Estonia. So let's say Vilnius, Riga, and Tallinn. And so now you have this sort of a exchange arrangement. You give them the flat in Helsinki, and in return you get 3 flats in 3 different countries. So again, you see, it's an exchange. Why would anybody do that? I don't know. Depends on a lot of things. But of course, what's relevant here is that it is a transfer of property, and of course, in different legal systems, it is taxed in a different way. So, well, it's not a sale because if I was to take your flat and in exchange give you money, that's not an exchange anymore, right? That would be a sale. But in this situation, we're looking at one property is transferred for another property or properties. And so Can there be a bit of money involved? Also, this could be quite an interesting question. So let's say I have a flat in Helsinki, and I want to let you have it, and but you don't have enough money, but you have a country cottage somewhere in Norway. So could it be that country cottage plus 100,000 euros is equal to the flat in Helsinki? Yeah, so there are a lot of these issues that arise. And again, from a legal viewpoint, the key is you have to put it in the right box. Yeah. Now, this could be construed as somehow a situation where there's a lot of inflexibility, but remember there are tax issues involved over here, and duties and other legal implications that arise, so which is why you have to keep them in mind. So sales, mortgage, lease, exchange, each of these um, involve a transfer of property, but as you see already, in a sale or in a mortgage or in a lease or in an exchange, there's a very different transfer of the interest. Transfer of the interest versus or vis-a-vis transfer of property itself. So we are looking at quite a few different ways of transferring property, different transactions. Each has its own meaning, its own implications, and its own legal issues that can arise. And of course, there are rights and liabilities. So rights and liabilities of parties in an exchange. Each party has a right and is subject to the liabilities of a seller as to what she gives, and has the rights and is subject to the liabilities of a buyer as to that which she takes. Yeah. So you see, in this exchange, the rights and liabilities are quite similar to what you would see in a sale, but of course, it's not legally a sale. Now, having covered this part, we next go on to gifts. And gifts are, of course, a very interesting area. And well, we all like to get gifts for birthdays or for anniversaries and things. And you know, I'm presuming most of you have had good friends or relatives and have received gifts at one point of time. And a gift could, of course, be something as innocent as a €100 Rimi voucher, yeah. Or it could be a stay in a hotel, or a package tour or a honeymoon trip or something that is gifted to you by your family and friends for your wedding present. It could be, for example, a car that is gifted to you. And well, we all like people who think about us and give us something instead of just some stupid flowers. Because what can you do with flowers? Chocolate gifts are also good, but yeah, we're talking about real gifts here, something that has money, yeah, or involves money. Now, of course, when we talk about these sort of things, of course, a gift could be movable property, it could be immovable property. A more important issue would be, what if I am engaged to you, and so as an engagement present, I give you a gift, of an engagement ring, and well, it's in anticipation of us getting married, and now it turns out that you don't like me anymore, and you don't want to get married. Okay, fine. You don't want to give me back the gift of the wedding ring as well. What the hell, I mean, maybe the wedding ring is worth a lot of money. So these are, of course, issues that arise. I've spoken about them in the past. But let's stop here for today, and I will talk about this very interesting area and the legal aspects that can arise in this regard later on. So we'll talk about it next week. So until then, thank you for your time, and see you again next week. Goodbye.